Hi guys, it's Kathy. I hope you're doing well. We made it to Wednesday. Yay! I got some doozies today. I do have one clip that some of you are going to leave for, and that's fine. It's short. It's 7 minutes long. I'll warn you when we get there. But this first clip is sort of like a slow burn. It's all legally at the beginning until he explodes. So just sit back and relax and wait for it. Bonjour.
Be ready to proceed and bring the jury out.
Yes, Judge.
Yes, Judge.
All right, you can bring out the jury. All right, you're going to see the verdict first.
No, we don't have the whole trial. Nope.
And Mr. Boygan, you're our foreperson, correct?
Yes, ma'am.
And has your jury reached a verdict?
Yes, ma'am, we have.
And is it unanimous? That is agreed to by all?
Yes, ma'am.
And have you signed and dated the verdict form, putting a decision in each count?
Yes, ma'am.
All right, if you will hand the verdict to our clerk. All right, and it's customary that the clerk publish the verdict, which really just means reading your decision out loud. Would you like to publish the verdict, or would you like our clerk to do it?
Clerk, please.
Okay. All right, go ahead, Your Honor.
In the state of Georgia versus Corey Maurice Rucker, in count 1, malice murder, we the jury find the defendant guilty of malice murder. Count 2, felony murder, we the jury find the defendant guilty of felony murder. Count 3, aggravated assault, we the jury find the defendant guilty. Count 4, possession of a firearm during the commission of a crime, we the jury find the defendant guilty. Count 5, theft by taking more than $1,500, we the jury find the defendant not guilty.
All right, any matters that we need to address with the jury as to the verdict first, Mr. Callahan?
No, Judge.
And if I could have an attorney from each side approach. And you can have a seat, thank you. And is the state and defense ready to proceed with sentencing?
Yes, Judge.
All right, and the state previously filed a recidivist notice that the courts had an opportunity to review. The exhibits that were submitted in the trial of itself, are you going to be relying on those?
Yes, Judge.
Can we get the certified convictions from the jury room? It was states 38, 38.
39, 40, 41, and 42.
Yes.
We're going.
And Mr. Callahan, do you want to review
Yes, ma'am.
39, 40, and 39, 40, 41, and 42 again?
Yes, Judge.
There you go.
Thank you.
And while Mr. Callahan is reviewing those documents, is the state going to be presenting any other victim witness statement or calling any testimony? Calling anyone for testimony?
Thank you so much.
Yes, he did. This I'm sure.
Lacey.
Judge, you can background.
And any objection to these 39, 40, 40, and 41 for the court's consideration?
No, no.
All right, give me just a moment.
Hi, Anthony. It's coming. Just relax.
And Mr. Callahan, do you still have 42?
My apologies, Judge.
Sorry.
I didn't. You got underneath one of my exhibits for some reason.
I looked for the same.
Yes.
This is a verdict we rarely, ever see. Ever.
All right, and let me hear, and is there any evidence that defense would like to present?
Judge, due to recidivist, there's putting up any form of evidence with the only sentence being life with parole and recidivist C, which essentially make this a life without a possibility of parole. There really is no purpose in putting up any sentence. Whether you're under a sentence under life or life without, recidivist C takes effect and essentially it's an outlaw sentence regardless.
And Ms. Fowler?
Yes, Judge.
That's you. Your life. Without the possibility of parole, you're going to be Fozzie's pants for the rest of your life.
Obviously, Mr. Callahan's correct. Having filed the recidivist notice, that does mandate a sentence as to count one of life without the possibility of parole.
Oh, that accent. Can we hear that again? Can we? Can we hear her one more time?
obviously Mr. Callahan's correct, having filed the recidivist notice, that does mandate a sentence as to count 1 of life without the possibility of parole.
And you're requesting that count 2 merge into count 1, count 3 merges into count 2, and then the possession of firearm during the commission of a felony is a 5-year consecutive sentence, even to a life without the possibility of parole based upon the statutory scheme, correct?
That's correct, Judge, although the felony murder, I believe, is vacated as a matter of law because of the malice murder conviction, and so then the aggravated assault merges into count 1. And I will say, Judge, if it matters to anyone, Mr. Alexander's mother has been watching the trial. She didn't want to make a statement. She didn't want to be here, but she has been watching.
Thank you.
Yes, thank you. Thank you very much for that.
Mr. Rucker, this case is so unbelievably tragic to me. Everyone here has seen what addiction can do, and the manner in which people live when their primary, what's sometimes seen sole purpose of existence is getting high. We have heard and seen testimony and exhibits of how Trampus, Carly, Victoria, and Destin lived. Maybe not lived, survived. And I can tell you that I will certainly remember that testimony every single time I drive by the Motel 6. I know that this case has made me especially thankful for a community and a circuit that works so hard on ridding our community of drugs and healing drug users, really one person at a time. For the jury, if you're not familiar with our accountability court programs in Hall County, I encourage you to come watch court. I encourage you to come to a graduation because you're going to see that accountability courts literally save people's lives. Because in reality, given how Trampus, Carly, Victoria were living, it's almost surprising that they were still alive to testify in the trial, given the severity of the addiction. And so for you, Mr. Rucker, when evaluating your credibility, when you testified, I noted that you wouldn't give names of anybody that you got drugs from. You wouldn't name where or give us a location in regards to where you purchased an illegal firearm from. And probably most concerning is where the murder weapon is in our community. I heard arguments and statements from you that Agent Job was harassing you. Agent Job was doing his job. You were a drug dealer.
I was a drug addict.
Excuse me. You don't get to talk right now. You were a drug dealer.
I was a drug addict.
Sir, your testimony was that you lived in a Motel 6 hotel room with multiple other people and watched them do methamphetamine for days, and you only used on day 1. That's not how addicts act. It's simply not.
Because I lived there for days because I was going to rehab. I was trying not to be high when I went to rehab. You're not understanding that. Y'all making it seem like I'm just this. He was my friend too. I didn't want him to die. He was my friend too. It's just mighty funny. Everybody forget the part of the story when it's time to tell the truth, but they remember what I do. But every time it's time to tell the truth of what they did, they forgot. Come on, don't you think that's suspicious? And you know why I didn't tell where I got my drugs from or the gun from? I'm not finna do nothing crazy because my life, I would die. I would die. Them people would kill me if I tell you that. Just like his mother is watching this court case, the people that I bought my drugs from is watching this court case. My life is in that danger. Now you finna send me to prison where I can die at? Because I wouldn't tell you what I bought my drugs from? Man, that is ridiculous, man. Come on, now, they're not the only victims in this situation.
It is my time to talk.
I'm a victim too.
It's my time to talk.
I know, it's always your time to talk.
And if you can't be quiet, you're going to be excused. Do you understand that? Because when I heard you say multiple times on the stand, I wasn't trying to hurt no one. Your business of peddling poison throughout this community hurt way more people than we will ever truly know. The impression that you tried to make to the court and to this jury that you were some sort of ethical or helpful drug dealer. Terms like ethical and helpful don't go with drug dealer. In reality, you helped customers to keep them your customers. And what you did on January 19th of 2024 was take the life of a man for no reason. Based upon your previous criminal history, that dictates your sentence. And the legislature has said when you commit 3 prior felonies, to include a very serious armed robbery and aggravated assault, and then commit the offense of murder, you're too dangerous to live within the community.
Yes, ma'am.
Your sentence in regards to count 1 is life without the possibility of parole, count 2 is vacated, count 3 merges, and count 4 will be 5 years to serve consecutive.
Yes, ma'am.
You're excused. Mr. Rucker, you have 30 days to file an appeal. The Public Defender's Office will continue to represent you to discuss that with you. And if they feel that you need conflict attorneys, they can do that, but ensure that your 30 days to file an appeal or motion for new trial is addressed, and habeas expires in 4 years.
And Judge, for the record, we'll be filing that notice today.
Thank you.
Ethical drug dealer and ethical hacker are the same thing, Kelly. Oh man, I need to make some split pea soup because it's so good. I ain't got time for that. Alright, now this is 7 minutes and 9 seconds long. I'm telling you how long it is because some of you are going to want to leave real quick for 7 minutes and 9 seconds. I'll try very hard not to pause the video at all. But I'm right. A dog does not make it through this video. So that's why I'm saying some of you might want to leave for 7 minutes and 9 seconds. Now, when you watch this video, don't forget, you can't say gun. You have to say poo poo, poo poo, poo poo poo. And you can't say, oh, dead or murder. You know, you got to say red rum, like Kelly did. Red rum. Oh, gosh, I hope there's peas and ham in it. Anyway. I'm starting the video. Now, a dog does not make it through this video. So if you need to leave, get out of here. Here we go.
What's the status of this one, Mr. Hyman?
No, this is a negotiated plea in counts 2 and 3.
Misdemeanors, okay.
Misdemeanors. The recommendation of 12 months on each to run consecutive, a $200 fine on each, drug and alcohol conditions for the amendment waiver, no contact, and early termination of probation after 12 months.
Anything to add to that, Ms. Adams?
That's great, Judge. As long as he pays his fines and doesn't have any violations, he can terminate at 12.
At 12. All right, Mr. Lim, it appears that you and Mr. Hyman in the DA's office have reached this joint recommendation here. Did you understand all of it?
Yes, sir.
And is that what you agreed to plead guilty to today before you came up here to the
Yes,
podium?
yes.
12 months each, concurrent, a fine on each one, and no contact with the victim.
Yes.
All right, Mr. Lamb. Well, before I can get to the disposition, though, I have to first go through a process with you where I ask you a few questions to make sure that you understand all this, but just as important that you understand all of the rights that you'll be giving up if you complete this guilty plea. If at any point during this process you don't understand my questions, and you need some more time to talk to Mr. Hyman, just let me know, and I'll give you all the time that you need within reason. Raise your right hand, please, sir. Do you swear or affirm under penalty of perjury that the testimony you give here today shall be the truth? Put your hand down. Mr. Lamb, do you understand you're pleading guilty to counts 2 and 3?
Yeah.
And this recommendation, that's what you agreed to plead guilty to before you came up to the podium, is that correct?
Yes.
They're both misdemeanors. They have a maximum penalty of 12 months each. The court just wants to advise you that you cannot be forced to enter a guilty plea today. You can maintain your not guilty plea, have a speedy and public jury trial where the state must prove you guilty beyond a reasonable doubt to the satisfaction of the jury.
Your Honor, he is proud to be guilty for this. He is proud. I think I would be too.
Because you have a presumption of innocence that would remain with you throughout the trial. You'd be entitled to have your lawyer with you throughout the trial. You could cross-examine all of the state's witnesses, defend yourself, bring into court your own witnesses, testify yourself if you wanted to, but you could not be compelled to testify because you have the right to remain silent. Mr. Lamb, do you understand? If you plead guilty to counts 2 and 3, you will be waiving all of those rights. Do you understand that?
Yes.
All right, Mr. Lamb, are you pleading guilty to count 2, criminal trespass, and count 3, simple battery, because you are in fact guilty?
Yeah.
All right, Mr. Hyman, see that his guilty plea gets entered.
Well, I need to show me my side. I got one of mine. I'm gonna wait over 12 months, pay the $400 off. No, you can pay it off. Yeah, yeah, I'm just gonna get that out of my way. More for 100 because yeah. But I should get it out of the way, you know. Get it soon as I can, get it out.
All right, here we go. Now we learn what really happened.
Down here? Oh, it's right up here. Oh, okay. Okay. Scribble. Doesn't get that easy.
Judge, the plea's been entered.
Facts of the case, please.
Yes, Judge. Back on October 29th of 2021, Katie Terry and Destiny Evans were walking their dog on a leash when several other dogs began to chase them. Mr. Terry shot at them with a .22 caliber gun and apparently struck one of them. That dog belonged to Mr. Lamb. Mr. Lamb approached them and asked, did they shoot his dog? And they said, yes, the dogs were chasing them.
This is Mr. Lamb. He owns one of the dogs that died.
And this ended in an altercation where Miss Evans was trying to separate them, and Mr. Lamb struck her in the face. And the criminal trespass is because he entered onto their property and instigated this altercation.
Anything from the defense? Anything from the defense?
Your Honor, just to add to it, they shot his dog. He went after him and said he was going out to fight him. He did do that. Then he went and got a baseball bat, hit Mr. Lamb with it. Come back out and beat me with a bat. Then proceeded to break about every bone in Mr. Lamb's face. And that's where we are.
Well,
and he's about 30 years old.
Yeah.
Whooped me, then went and got a bat and beat me with it.
Well, Mr. Lamb, I mean, it's not up to me to decide what you should do now.
I done took it up with the Lord has.
Well, that's a much higher power than me, sir.
That's why I say, I can't do nothing about it either, Your Honor. The bat shot my dog, and I can argue the case all I want, but if you shoot my dog, we go into the ground. That's all I can say.
Mr. Lamb, again, I'm not.
I know.
I gotta be careful what I say. All you gotta do is tell me you want to plead guilty or you don't.
Yes, sir. I just don't want to bother the courts. All right. Time and stuff.
Court finds the plea is freely and voluntarily entered. There is a factual basis for the plea, and the court will accept the plea. Guilty plea to count 2 and 3, and the sentence will be as. Joint recommendation, 12 months each consecutive, $200 each plus the add-ons, drug and alcohol, Fourth Amendment waiver, and terminate after 12 months upon payment of all fines and fees and no further violations and no contact with the named victim, who is who? Well, whoever it is.
It's Cody Terry and Destiny Evans.
Cody.
All right, you'll need to meet with Ms. Mitchell here for probation. She'll process you through, Mr. Lamb. Good luck to you, sir.
Yes, sir. Y'all sorry about that, y'all.
Yes, drunken Mr. Obvious. He failed to keep his dogs under control, and the dogs were chasing the other guy. So I get why the other guy did what he did. I get it. Yeah, I guess it's normal to walk your dog with a gun. Anyway, he stood up for his dog and he got his butt whooped. They took a baseball bat to his face after shooting his dog. Okay, alright. That was 7 minutes. I hope whoever left, I hope they're coming back now because we're moving on. This guy is brilliant. He is the smartest criminal I have ever seen.
All right, who's up, Mr. Hyman?
Your Honor, this is 22R2407, Sean Rango.
Number 12 on our plea calendar today. All right, what's the status of this one, Mr. Hyman?
We've got a negotiated.
All right, give me the terms of the recommendation.
He's going to plead to count 4. He's going to tender that, assuming that he qualifies on the First Offender Act.
I was waiting. Now you guys.
The recommendation will be 10 years probation.
He was in the last video, was he not? Wasn't Mr. Hyman in the last video? I thought he was.
Hi,
man.
Drug and alcohol conditions, Fourth Amendment waiver, $1,000 fine, and ban from the Department of Corrections.
Okay. And count 4 is possession of marijuana with intent to distribute.
Yes, Your Honor.
You're going to plead as alleged?
Yes, Your Honor.
And what is the range on that one?
1 to 10.
With intent to distribute is 1 to 10?
1 to
Okay.
10.
1, 2, and 3 be null pros?
Yes, Your Honor.
All right, Mr. Orango, it appears that you and Mr. Hyman in the DA's office have been working on your case and have come up with this joint recommendation, or a negotiated plea, as we call it. I'm going to have a lot of questions for you in just a moment, but I'll note for the record that you are standing at the podium with your attorney, and did he announce everything as you understand the agreement to be?
Yes, sir.
Before I can get to the disposition phase, I have to first go through a process with you where I ask you a series of questions to make sure that you understand all the details of this, but just as important, that you understand all of the rights that you'll be giving up if you complete this plea today. If at any point during this process you don't understand my questions or you need some more time to talk to Mr. Hyman, just let me know, and I'll give you all the time that you need within reason. You understand everything so far? All right, please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you give here today shall be the truth? You can put your hand down. Mr. Orango, do you understand that you are pleading guilty under the First Offender Act to count 4 in this indictment? And do you understand the sentence recommendation of 10 years on probation, the fine, and all these other conditions? Do you understand all that, Mr. Orango? And is that what you agreed to plead guilty to before you came up here to the podium? As I stated a minute ago, before I can decide whether or not to accept all this, the court must first determine that you are making a knowing, intelligent, and voluntary waiver of all of your rights, that you know and understand what you're doing, and that you're doing it of your own free will. So it's vitally important that you speak up if something happens that you don't understand. Count 4 is possession of marijuana with intent to distribute. That is a felony. It has a maximum sentence of 10 years in prison with a range of 1 to 10 years in prison. Now that's important for lots of reasons, but I understand you wish to offer this plea under the First Offender Act.
Don't worry, guys. He's not going to go to prison. I'm just telling you that up front. He cannot go to prison. They cannot send him to prison because he's brilliant.
The court does advise you that if a first offender probationer violates the terms of this probation and the court later enters an adjudication of guilty, the court may then impose any sentence permitted by law for the offense you're about to plead guilty to. At a probation revocation and adjudication of guilty hearing, a first offender probationer may then be resentenced to a sentence greater than what you get here today, up to the maximum amount allowed by law. Do you understand that? And you wish to proceed with the First Offender Act plea, is that correct, sir? Court does further advise you that you cannot be forced or compelled to enter a guilty plea today. You can maintain your not guilty plea and have a speedy and public jury trial if that's what you wanted, where you would enjoy a presumption of innocence that would remain with you throughout the trial, and the state would have the burden of proving your guilt to the satisfaction of the jury beyond a reasonable doubt. You would have the right to be represented by your lawyer at all stages of the trial. If you could not afford to hire a lawyer, then at your request, the court would appoint a lawyer to represent you without cost to.
Everybody needs to say hi to Nan again, just in case they missed her. Or she missed it. Hi, Nan.
You. In the trial, you would have the right to confront, question, and cross-examine all witnesses and persons who accuse you. You would have the right to defend yourself and to bring into court your own witnesses and evidence in your behalf. And at your request, the court would issue subpoenas direct to your witnesses to compel them to come to court. You would have the right to testify in your own behalf, but you could not be compelled to testify nor to incriminate yourself, because you have the right to be present throughout the trial, including the right to be present and remain silent. You would also have the right to ask the court to suppress any illegally obtained evidence, and if the jury should find you guilty, you would have the right to appeal that guilty finding to a higher court, and that would include the right to be represented on that appeal by either your court-appointed attorney or private retained attorney, as the case might be. Mr. Arango, do you understand that if you plead guilty today under the First Offender Act to this account, to this charge here, you will be giving up or waiving all of these rights that I've just explained to you for this case? Do you understand that?
Yes, sir.
Fourth Amendment waiver will be a condition of this probation. Do you agree and understand that as a special condition of probation will be that you shall submit to a search of your person and property at any time of the day or night, with or without your consent or a search warrant, whenever requested to do so by a probation officer or a law enforcement officer? And if anything is taken, it may be used against you as evidence in a further court proceeding. Do you understand that?
Yes, sir.
Now, you're represented here today by your attorney, Mr. Hyman. Is that correct? Have you had enough time to talk to Mr. Hyman about your case? Do you need any more time to talk to Mr. Hyman about anything involving this case? Do you have any objections as to how he has handled your case? Is this your free and voluntary plea? Has anyone threatened you or frightened you to force you to plead guilty? Other than this plea recommendation, has anyone promised you anything to get you to plead guilty? Are you under the influence today of any intoxicants like alcohol, drugs, narcotics, or prescription medications? Is your mind clear today? Do you know where you are and what you are doing? Can you read and write? Do you have any questions about any?
It's okay. We're about to get to the part that's brilliant. As soon as he starts giving him this sentence, here we go.
Anything that's happened up to this point. If you are not a United States citizen, a guilty plea will affect your immigration status. Mr. Arango, are you pleading guilty under the First Offender Act to count 4, possession of marijuana with intent to distribute, because you are in fact guilty?
He was trying to bring marijuana into a prison.
All right, Mr. Hyman, see that his, other way. See that his guilty plea, First Offender Act plea gets
Quiet for a second. Then it gets loud again. Come on, Judge.
Yes, Judge, this case occurred back in the late night on April 23 into the early morning of April 24 in 2022. Mr. Arango drove his co-defendant, Mr. Antares Jackson, to over here in Chester, Dodge County, Georgia, to the Dodge State Prison, where they brought items of contraband to include marijuana. Unfortunately for them, they were intercepted over at the prison.
anything from the defense, Mr. Hyman?
No, Your Honor.
All right, Mr. Arango, do you have any questions about anything that's happened? Anything that you would like to say? You don't have to, but you can if you want to. Very well. The court finds that the plea has been freely and voluntarily entered, that there is a factual basis for the plea. The court will accept the plea and the First Offender Act recommendation, and that will be the sentence of the court on count 4. 10 years on probation, a $1,000 fine, plus the add-ons that go with it. Be served under drug and alcohol conditions, Fourth Amendment waiver conditions. You have a period of 30 days to file a notice of appeal or a motion for new trial, and you have 30 days.
Quite the opposite. Hold on.
To, 4 years to file a habeas corpus petition from the date the sentence becomes final. Do you possess a concealed carry permit for a firearm, Mr. Orengo? And also be banned from all Department of Corrections facilities. You'll need to meet with Deputy Chief Lee here. He'll process you through, but that will conclude this matter. Good luck to you,
Were you
sir.
done? Oh, I missed it. Okay, he said it. I just was talking to chat and missed it. So he's banned from the Department of Corrections. He is not allowed to go to the Department of Corrections. He is banned from there. He can go out and do whatever he wants now because the judge banned him from jail. He's not allowed to go to jail. I just think that's brilliant. Listen, guys, you got to think outside the box all the time, not just some of the time. So go real quick right now and try to drop off some marijuana at a prison so you can get banned from prison. Okay. Brilliant. All right. Irritating lawyer, guys. Irritating lawyer alert.
Well, I have a plea to review with Miss Aragon, and then, we can go forward with Miss King now.
Ms. King, if I can have you come forward, I'll open the record in 24 CR 5000 and 24 CR 39. I note the appearance of Mr. Bachlet on behalf of the people.
Nope, they won't vary.
Maggie King present today in person. She appears with Mr. Zane. We are scheduled today for an arraignment. As the parties, or as Mr. Zane indicated, there was a motion filed today in each case to revoke Ms. King's bond. Mr. Bachlet, do you want to supplement the motion?
So, Your Honor, yes, please. I would just note that at our last appearance, the court specifically reminded defendant that it was a condition of her bond that she submit to UAs. At that time, they were referring to a December report that indicated she had missed 25 UAs and made 16. The updated report from January 13th now notes that she hasn't made any additional UAs completed. She's still at 16, has missed 41. When we look at this particular set of cases, essentially we have 2 DUI charges, vehicular looting in one of those cases, driving under revocation within the course of 3 months. We look at the defendant's record, and some of these charges are pretty old, and that cuts 2 ways. We have 02T112 out of Crowley County, driving while ability impaired, 09T543 out of Otero County, driving while ability impaired, 17M115 out of Otero County, DUI. And then we have 2 this year or last year. So we can say, 1, well, those are really old, or we can say since 2002, the defendant continually struggles with not only making the decision to drink, to abuse substances, but then to get behind the wheel, including twice in 3 months last year. There's a reason why the requirement to do UAs was put in place as a condition of bond. The defendant and her counsel had the opportunity to argue that this was not something she could possibly do. She was able to complete the first 16, or 16 of the first 25, but then we've just completely fallen off the radar. We're looking at somebody who has an extensive criminal history, who obviously is not following bond conditions, and who is a very serious risk to the community. And based on those factors, and the fact that she was told point blank at the last hearing, you need to go do those UAs. And she said, well, I can't afford to. Well, okay. If you can't afford to, have we provided any documentation to the court saying that we're going to AA? Have we provided documentation to the court saying, oh, I can't do this? Have we tried to go even one time and take a UA? Not one time. So we can say we can't afford to do it, we don't have a ride, but in the end, if you don't make any effort, then it's pretty clear that it's not about other things, it's about just not having the will or the willingness to do that, to follow bond conditions. And bond conditions aren't made exceptions based on who you are or where you're at in the world. Individual circumstances can be considered, and that's why I mentioned her record and the fact that initially we were completing some, now we're not. And the fact that the danger to the community is so great based on these type of offenses. So particular circumstances are considered to that degree. And I think that having a cash or surety bond, having a bond that ensures the safety of the community and that recognizes when we're just ignoring the conditions of the court is appropriate. And that's why I chose to file the motion. I waited until I saw that last report. I waited until I saw whether or not the defendant was trying to comply, because I felt that she deserved the opportunity to show that she was actually trying. But we don't have anything filed with the court. And again, AA is free. Anybody can go to treatment. Anybody can get on the phone and call up a counseling service and document that for the court. If we can't afford to do something, one thing, we can at least show that we're making some efforts. If we're not making any efforts, then at the end of the day, it's for the court to say, you have to follow the conditions of bond, whoever you are. Thank you, Your Honor.
Thank you, Mr. Bucklet. Mr. Zane?
It's not a matter of me asking the court for particular bond conditions. The monitored sobriety is something that was legislated into the conditions of bond for people with a prior. So to say that I somehow should have argued for a variance, that's just not understanding the law. The fact that the motion was filed this morning, I think is inexcusable. Absolutely no reason for the people to wait 3 hours before Ms. King is to appear in court to make this allegation and file this motion. This could have been done when Judge Karn brought it up 2 weeks ago, so we had some notice. But the people are talking out of both sides of the mouth, right? They're saying, oh man, we need UAs because Miss King uses substances and gets behind the wheel of the car. But in their request and in their requirements, they're forcing her to do exactly that. Where in this town can she walk to get a UA? She can't. She's got to go all the way to the east side of La Junta to get a UA done. They're $20 a piece. And these cases have been going on since March of last year. And so let's talk about why they're going on so long and how many, and think of it in terms of how many trips that would require for her to somehow get to La Junta, pay the $20 for the UA. But so when these cases first started, Judge, we did not have blood test results. When we appeared back at the end of March in 2024, we didn't have blood test results until July of 2024. 4 months. So, okay. CPI dragging their feet there. It's required her not to be able to resolve this case in any way in a timely fashion. Then, in October, when Miss Marsh was here, I received the following offer, and I've put this on the record before. Mind you, to resolve a vehicular eluding case and a DUI fourth in 2 different cases, the offer I received was plead guilty to a DF3 in the drug case and one of the DUIs and dismiss the 3rd case. Stip that they're all concurrent, all other terms open. Okay, where do we start with that? There's no 3rd case, there's only 2. There's no DF3. And I repeatedly asked Miss Marsh to look at the cases and come up with an offer that actually made some sense based on what Miss King was charged with. Didn't happen. Didn't happen in the month of November. Finally, I meet with Mr. Bullock on December 10. We have a discussion. That discussion includes an offer that is related at this time, finally, to the charges. So remember, this has been going on since March. It's December before we have an offer that we can even consider, one that even makes sense. I make a counter offer on that day. Mr. Bullock's going to consider it. We come back January 14. Mr. Bachlet, I'm new to this. I need time. I got to look at this. Okay, we'll set it over for 2 more weeks. I still haven't gotten a response on that. 6 weeks ago, I made a counteroffer that they can't respond to.
Maybe nobody likes you. Did you ever think about that?
Probably took them 45 minutes to file a motion to revoke Miss King's bond, but the guy can't spend 5 minutes reviewing a counteroffer that I made 6 weeks ago. Like, how long is this woman supposed to travel back and forth to La Junta to do UAs? When we know she can't drive, the people don't want her to be driving, but she doesn't have anybody who's going to take her. And we did put that issue on the record 2 weeks ago when we were here. So it puts Miss King in an impossible position to comply with conditions that are unfair to her, that she can't possibly comply with. Unless the DA's office is going to send somebody to take her, or the Crowley County Sheriff's Office is going to drive her to La Junta every time she has to do a UA, and somebody's going to pay for it, there is no way that she can do it. And what it ultimately comes down to is mandated conditions of bond by our legislature like this are unfairly punitive to people who don't have the financial resources to pay for it. And that's Miss King. She doesn't get Social Security. She's barely getting by, barely has any.
But she has money to buy alcohol and then drive, potentially killing everybody.
Anything to eat, let alone traveling once a week, twice a week, 3 times a week at the beck and call of some random system and relying on other people to do it. How is she possibly realistically supposed to do that? Now, ever since the 24 CR 39 case, which I think was in June, she hasn't had any other criminal cases. There's no pressing need where she's out driving around using drugs or anything like that. That there's no allegations whatsoever of that. The allegations are simply that she can't make it to the UAs anymore. And she did it for a while, but she exhausted every resource that she had to get there. And now she doesn't. If you want her to do UAs, make them available at the sheriff's office right here. Find a way to help people pay for them, because it is not realistic to say that she's got to drive 40 minutes. Nowhere else in the state would somebody have to do that. If she lived in Colorado Springs, if she lived in Pueblo, be fine. But here, the conditions are too onerous. They're not the least restrictive conditions of bond, right? That's what 16.4.101 et sec requires this court to do. Take into account the individual circumstances of Miss King. Take into account the individual financial circumstances of her and the circumstances that she finds herself in, and fashion the most reasonable, not overly restrictive conditions of bond. And when you make somebody travel 80 minutes round trip and pay $20 a UA to do it, we have
Okay, all of us here are not lawyers except for Peg Leg. And I'm just thinking that his whole argument is against the law. He's arguing she can't follow bond conditions because the law's not right. Well, the law is the law. He's asking the judge to break the law. Is that I'm hearing him ask the judge to just break the law. No UA's for you. You're fine. It's just your 4th DUI.
Unreasonable conditions of bond that are unduly punitive to people without financial resources and puts Miss King in a position where she can't comply with her bond, even if she wanted to. And that's not a fair basis to turn around and say, well, then she needs to be in jail. Or, well, let's add more monetary conditions to this. Like we're going to teach her a lesson, right? It's not that she doesn't want to pay. It's that she can't. But we're gonna teach her a lesson by adding a monetary bond. Now she'll have to go through a bondsman that everybody knows she can't post, and further take whatever resources she might have to eat and do UAs away and give it to a bondsman. Doesn't make any sense. That's more restrictive. So, Judge, I get the fact that our legislature decided to issue this unfunded mandate and require people to do these things, but didn't bother to give local jurisdictions the money to make UAs available so people didn't have to drive.
I don't know the court appointed in this courtroom yet. So I don't know if he's court appointed or if she hired him with money that she just doesn't have. So I'm guessing court appointed.
My God, if you take somebody's driver's license, you tell them they can't drive, and then say the only way you stay out of jail is if you drive 40 minutes and pay $20 a UA, you put them in a position where they can't possibly comply with bond. So I disagree. And I don't think that people have the first shred of evidence that suggests Miss King is not taking these UAs because she simply doesn't want to or simply doesn't care. She's not doing it because she can't. So I'd ask you to take that into consideration and find some other way that she can be in compliance with the conditions of bond that don't require significant financial expenses, because the ones we currently have do. She's not going to be able to comply with that, and she shouldn't sit in jail just because she's poor. That's not how things happen in the 16th. Maybe in the 3rd, but not in the 16th. That's not what we do. These are not debtors' prisons.
All right, thank you, Mr. Zane. Mr. Bachlet?
You're all right. Just note, to supplement, looks like on June 25th, actually, an offer of DUI second was extended to Mr. Zane by Ms. Marsh. So I have to correct the record in that sense. Otherwise, I'll just stand on the argument that I've already made.
Judge, it didn't consider the second case that came out almost right at that time.
Oh, he's so annoying. He is so annoying. Did he hear what he just said? Revoke, just revoke.
Thank you. The court is concerned. I have addressed with Ms. King previously that the order is as part of her conditions that one, she, not possess or use or consume any alcohol or controlled substance.
There's more.
And that must be monitored, and that is a requirement, as Mr. Zane has mentioned, that is a requirement by the legislature that the court order that's just a condition of bond that the court has no discretion over. At least in my opinion, there's no discretion left in there in the statute. There's also not a consideration for the person's ability to pay. That's not in that specific condition that the legislature mandated. The other thing that I would note is from the reports is, part of the order of the bond conditions is that you not consume any alcohol or controlled substance. That includes marijuana, that includes amphetamines, and all the tests that you did submit to were positive for amphetamines and marijuana.
Yep, she's completely broke. She has absolutely no money, Judge.
Maybe one of them was just marijuana, but the others were both amphetamines and marijuana. So that is also concerning, because it's not only the issue of not being able to afford to submit to them. When you have been able to afford to submit to them, you have not abided by the condition that you not possess or consume. alcohol or controlled substance, specifically the controlled substances that I just mentioned. What the court is going to do is I'm going to hold both motions in abeyance. Ms. King, I'm going to make it just absolutely clear to you that if there is a violation of the bond conditions, that your bond will be revoked, okay? And that will unfortunately place you in custody, and that will mean that there'll be a cash or surety bond, and if you're not able to post that, you would remain in custody until that can be resolved. I want you to take this seriously going forward. I don't know all the transportation that might be available to you here in Ordway. I have heard from others that you can set up certain rides. Sometimes med rides can happen if you're in treatment with some of the agencies that provide treatment, that you can set up med rides with them. Sometimes you can do the UAs through the agency that you're doing your substance abuse treatment through. So if you engage
but she's not doing substance abuse treatment, Judge.
In substance abuse or mental health treatment, as part of that, you can also ask them to do UAs, and a lot of times those are covered, or at least they can make arrangements to have them as part of your treatment plan, right? That they develop. I don't know what efforts you've made in regard to that. I don't know any efforts that you've made to address treatment, right? Which potentially will be an issue that will be ordered by the court, will be something that will be ordered by the court if you enter a plea or you're found guilty of the offenses. I want you to look into each of those, and I do want you to, come back next time with what efforts you've made to make the UAs and what efforts you've made to address the substance abuse, if you can get that all kind of wrapped into one. Does that make sense? All right, so right now I'm going to hold that in abeyance. I'm not going to issue an order on the motion to revoke, and that's going to be pending what you do and what you decide going forward, okay? Mr. Zane, how much time do you need, or maybe you should ask Mr. Bachlet how much time he needs to provide an offer so that we can come back for an arraignment?
I would defer to the people. I've been waiting on this one. I don't know. I'll just defer to them.
Mr. Bachlet?
Offer was extended, as defense counsel noted. He made a counter offer. It sounds like what we need is perhaps an arraignment date, and we can continue any negotiations up until that date, if that's satisfactory with the defense.
Or can we use the next court date then? That would be February 11.
Yeah, I just need to know before 9 o'clock in the morning, the day of. That's all I ask.
And so what you're waiting on is, do they accept your counter offer, or is there they stand on their previous offer, or
right? Is
there a new offer? Is that right?
There was a counter offer made 8 weeks ago, something like that, and I'm still waiting on an answer.
Okay, very good. So February 11, and we'll do that at 10 a.m. That'll be set for an arraignment. Ms. King, can I verify with you that you understand that will be your next court date? All right, thank you, Ms. King.
That was at 10, Judge, I'm sorry?
Yes, 10 a.m. The court will be in recess on both of Ms. King's cases. Can we do Mr. Forsman?
Okay. I already know that besides Peg Leg, the next clip is going to bomb and no one's going to like it. But I'm playing it. I'm going to play it. I don't care. So, this court drove me insane. It's pure chaos. Nobody knows where everything is. Nobody knows what the people in jail are being charged with. Everybody talks at the same time. So nothing crazy happens in this courtroom. But I'm playing this courtroom because it's loud and just unbelievable chaos the entire time. And nobody knows anything. And it's just, from what we're used to seeing, this courtroom is crazy. And there's something that makes it even crazier. It's in Washington. Now, almost all the clips that I used to play from Washington when I did YouTube judges. Everything was so ordered that it was super slow. The whole case was super slow because everybody was signing the documents, and uploading them, and one person couldn't get it until the other one was out. Everybody waited, and it was quiet, and it was orderly, and it was super, super slow. And then we get this absolute chaos.
I can't remember which place you're from.
Let them fall. 4th of July.
Right. Now I knew that. I met you a couple times, but I can't remember which agency you're with.
You've known me for 18 years.
I have known you for a long time.
Since Howard County.
Was I nice to you? Sorry.
Prosecuted you on the charge.
Well, I wouldn't have prosecuted you in town. I was prosecuted in Yakima, in my town.
I'm pretty sure you were the prosecutor. I know my brother. It was a militia mission charge.
Well, it's all in the past now?
18 years. Come on.
That's funny. My family is all ended up here. Your mom said.
Yeah, we all ended up here.
What about that? Okay, discuss.
Well, I came here for your best friends. Yeah. Well, life's been good since I got another house, started out with grandkids. Life's good.
Hi, baby. How's jail? Are they treating you okay?
Help me out with this gal today. I really felt bad for her.
No. He jokes with everybody. This is Washington.
But a lot of times that's through trauma, first of all, make bad choices.
Yeah.
And a lot of times also.
So he prosecuted her
father, brother. You know, that's something I understand from them.
And they're just talking about how he prosecuted her family.
How many people take it so they really don't have time? You're outside and you don't talk to those people. You don't understand why they go for other reasons. You go for somebody here.
We're here, just whatever. Yeah.
Something else. Anyway, Mark was worried about his paperwork. Got new stuff. There's police. We can start anywhere.
We just need a couple other folks.
Yeah, we need our MLS help.
We need the person in charge.
We need the person in charge.
Oh,
You want me to get the person in charge?
Yes.
Clerks run everything. Looks like head nurses and the senior secretary.
Right.
And most judges will acknowledge that.
Oh, ladies. In the middle of all of this, an angel speaks. In the middle of all of this, an angel speaks right to us. Get ready.
Heartbeat.
You know, nothing works without a clerk. Yeah. Nothing.
Once you're in district court one, if you're in front of a judge that has a ego that precedes them.
Right section.
They lost the court clerk. They're trying to find the clerk, guys. That's why they're all waiting, because they're trying to find a clerk.
Yes.
Which case is yours?
I'm just saying there's a reason that the head was the general secretary.
Police been here about 5 minutes. I don't know if I can hear it or not.
Very quick.
I can, sir.
Always be nice statements now. Always be nice to paralegals, because they run the operations, and you're just making life hard on yourself.
Okay. He's about to go on record now. The clerk is there and start the cases. So you would think the court would just, people would sit down and, things would be quiet a little bit.
Also, you don't know.
Just waiting for the boss. That's all.
This is support staff. They make you
Paperwork flow.
And if they agree, they make the job impossible.
Are we starting?
We need Mr.
We lost Mr. Flake, and you may all be seated. Mr. Paganelli, make yourself comfortable.
He flicked out.
We're in session, and we're going to start with police.
I'll just wait for Mr. Black, but
Mr. Polite has 3 cases, 2 of which are city cases, one of which is a state case. I guess I'm kind of confused. And I'll defer to probation, but I'm kind of confused when Mr. Polite is in custody. Did it go to warrant?
Yeah.
He absconded supervision. Resumed using drugs.
So on the probation matter, I'm showing there was admission back in October.
That's right, yeah.
And I'll defer to probation, but I thought he did inpatient and did a bunch of treatment. And then
He did.
It sounds like there was some bumps along the way.
There's some bumps. And Mr. Pleat, run that by me again. You're actually not working right now, are you?
That's correct, Your Honor.
But normally he'd be working, except stuff's going on.
And then the 2 city cases, one was a driving while license suspended. The Malamish, I believe, was also potentially alcohol related. So the hope was that he would stay compliant with treatment and we'd figure out a resolution of those 2. So well, yeah, but
Always an option, you know, I know you don't use it all.
so for today, it probably makes sense to address probation since Ms. O'Brien's here.
And we do have petitions.
You have a petition, Your Honor.
Oh, if there's new petitions, I haven't.
No, I just want to make sure because I'm looking for a petition in 687.
But there was admission on the.
Give this file, I'll be
Okay.
right back.
There was admission on the previous petition, but if there's new petitions, that's
We don't even have this on the copy of the docket we have, so I'm just gonna go. Joshua? Okay, I'll just go see the rest of this stuff. Anything she wants to add. That's not what you're talking about.
I just got to see the petition is all. I don't see those in my file for some reason. Is that this? That's the.
Yeah,
Petition file, December.
Okay. Do you see a petition? I didn't.
and I'm showing there was.
There it is. I got it. We got it. My clerk found
Showing
it.
there was admissions in October.
Right. You just see the August one?
For the August one, there should. Yeah, for the August one, there should.
You got the August.
You don't have December?
Do not have December.
Oh, I don't even have Mr. Paganelli's signature on mine, but that doesn't always mean it.
No, we can file the petition as long as we have one.
Right here.
There was admissions in September, so
That would be for the August
that's for
one.
the August, but my notes do not indicate anything for.
We don't have the new one. But yeah, you're gonna go make a copy?
Yes, Mr. Paganelli signed it first.
Well, Mr. Paganelli might want to sign it.
It's possible that you've signed.
Don't worry, Mr. Police. We're trying to figure out which probation violations you have. The August one, Mr. Gressler, was failed to maintain total abstinence, failed to follow treatment recommendations.
Yeah, and there was.
So you signed it
that back in September.
in December. I just don't have a signed copy of your signature. So this is
Right.
12/15/24.
But
You signed it.
That's
I just don't
December,
have a
that's
copy.
a copy.
No, and I haven't, we're gonna arraign him on those today once we see it.
It'd be admit deny.
Well, you know what I mean.
Because that
I haven't seen the meters on Wednesday.
Okay. So would you sign the front page on that?
Yep, you also want me to date it? No.
No. Because you didn't sign you didn't do the first one.
Once I get a copy of the December, is just procedurally enter denial on the December violations because I need to discuss those with my client. Why is he leaving?
I don't know. Oh, he's closing the door so he can hear. Mr. Police.
And then on the two city cases, just have those
He's closing the door so he can hear.
track along and keep this on the 11 o'clock calendar because I need to discuss those with Mr. Black.
Mr. Plead, do you know what your current address is, or mailing a good address?
1515 Kalawa Way.
Oh, wait, okay, the 1550. At your place?
That's my place, yeah.
All right. So we're gonna review this new petition here right now. That's okay. I'll just if I can just.
I'll
Just have to be able to tell them what the violations are.
No one knows the violations. Judge,
This is the one he
ask
has.
him.
Yeah, and just
Just ask the inmate. He knows.
looking at it, I would, for today, would enter denials, and then I would suggest putting all 3 cases on the 11 o'clock calendar, probably for March 17th.
Yeah. Till somebody says something, I'm not willing to.
Ladies, don't forget to listen. Because I'm telling you, an angel is going to talk. An angel.
I'm not prepared to address conditions of release until I didn't realize he was in custody. Because there's a series of reviews where he was out of custody and then treated that this was.
There we go. So the news petition on the 6871-23, failure to maintain total abstinence and failure to regularly attend prescribed alcohol and drug treatment program, failure to attend probation appointments as directed. Basically, Mr. Polita, I'm left with the impression that you've absconded from your responsibilities and that you're probably using. I don't expect an answer from that, but that's my way of telling you that we're not going to change bail. You're going to have to post whatever it is. It's at least the 3,000 on this one, 3,300 or 3,000 on this one. I'm not sure about the other two, but are you going to be able to post bail on any of these?
Not at the moment, Your Honor, no.
All right.
So, Your Honor, yeah, I procedurally.
The judge just said there's $1,000 bail on this one, but I have no idea what the other ones are. Are you going to be able to post bail? You didn't tell him how much bail was because you don't know. So how is he supposed to know? I am Bill Henderson.
Southern denial to the December violations.
Right.
And then just put all 3 cases for March 17th.
March 17th is when we're coming back.
Discuss things both with Ms. O'Brien and Mr. Fleck.
And that'll give you and your attorney a chance to talk about what your options might be. One of the questions for the court would be, did he complete treatment or not? That's not for you to answer, Mr. Polite. That's for, we're thinking out loud.
As far as I know, he was doing well up until about the December time frame.
Gotcha.
Again, that's the discussion.
Right. All right, Mr. Polite, we're going to see you March 17th at 11 o'clock.
Okay, thank you, Your Honor.
Thank you, sir. Do you want to go alphabetical? Is that good as to Shayla? Shayla Davis, is she online there? She was last time, wasn't she? Don't have anybody online.
This is a case, I think there's a prior FTA. Yes, there was a couple of prior FTA. Oh, that's FTA on January 13th, went to Warrant.
And 27th.
On the 27th, there's an FTA. We were hopeful because I have a Superior Court case with her. That too went to Warrant just this last Friday. And I was hopeful that she was going to show up today because that way I could explain she's got a felony warrant, but she's not here. So I'm assuming the state's going to be asking, or excuse me, it's the city.
We got both.
We have both? Oh.
The city has a malicious mischief DV. The state's got a protection or a violation. Since she's got bench warrants floating around, Mr. Fleck, Shayla Davis.
Yeah, she wasn't here a month ago. Right. We had asked for a bench warrant, and I think what happened is she came in later in the afternoon.
Right.
And we're on Zoom is kind of what I believe. That's what I have on my notes.
So we can correct me. I'm thinking about $1,000 cash on the state case. That's the violation protection order. And then $500 cash on the malicious mischief of the city. Does that work?
I don't have a problem with warrants, Your Honor. My fear is.
Yeah.
See her around 2 o'clock.
Well, we're going to issue warrants.
I'm just going to put the marker out. Issue warrants, and if we see her around 2 o'clock, I might be available because I might have district court.
She might just go to custody, except that she's in Port Angeles, I think.
Well, she also has a felony warrant.
She has a felony warrant. So I think we got to put her in custody.
Oh, yeah.
Right.
Okay. I'll put that down on that little one. I'll put the preliminary notice that she does show up this afternoon, so the state would object to any.
No, she's got a felony warrant. We're having bad luck here. How about it?
Trying to explain to Ms. O'Brien, Mr. Preston's old brother, where the approach to some of his defendant's class.
That is such a great
idea. The water's just fine. They'll wipe away all your sins. And just to confirm, that's 1,000 on the state matter?
1,000 on the state, 500 cash for the city.
Oh my God. Did you hear it? I'm going to play it again because it's hard to hear in this courtroom. Don't worry, he says more.
That is such a great
The
idea.
water's just fine. They'll wipe away all your sins. So, and just to confirm, that's 1,000 on the state matter.
1,000 on the state, 500 cash for the city. All right, so Mr. James Wilbur is not on there. James Wilbur.
There's more.
And this is the guy who was sent to treatment, and we are all kind of thinking that's where he's at, but none of us can prove it. But then we had an update that he was possibly
in the hospital last time.
But the unfortunate, he was up in the Nia Bay jail, was supposed to go off to treatment. And while he was at the Nia Bay jail, they were able to get him on Zoom.
Right.
It sounded like the tribe was sending him off to treatment, but we didn't get any updates. And then we missed the court date, and then we had an update the last time we were here that he might be in the hospital. But again, we didn't have any updates or written confirmation. My office has sent letters to his last known address. I'm assuming the court also has sent notices. So I have no information.
You know, my case is a disorderly, so I mean a bare minimum bail at the most, in my opinion.
Yeah, he's probably down at being bail, I bet you. Who knows? How about we just do 100 and 100? FTA bench more, $100 cash on each.
Yeah. Let me check. How about a malicious mischief, which could be about the same as the city's.
I don't know, but he's going to come to town sometime, and Raleigh's going to see him. He's going to be in jail.
And the second certainly true. The first I am less familiar with.
Okay. Yes. This is this, whoops, I can't think of her name. I just looked at her an hour ago, 2 minutes ago.
I actually love men. I don't find them particularly useful, but I still love them.
Is this Jeannie Thomas?
No.
This should be Courtney
Shanahan.
Yeah, this is the case that was on the 9:30 docket for the state.
Right.
Which I had set for an arraignment, but my understanding, she was PR'd on that case. But she was taken into custody on a city case, so it was bumped to the 11 o'clock.
Right, so, can you hear me okay, Shannon?
Yes, sir, I can.
Okay, I got these two cause numbers. Let me go Yeah, you're going to get appointed on the new one. She was on jabs, I thought.
9:30. She got moved to 11.
Oh, she got moved to 11. There she is.
Here, so on the case that was scheduled for arraignment, that is 7507-0025, that's a state case.
Right.
Here's my notice of appearance. My understanding that she was PR'd on that.
She was PR'd on it.
The reason she's in custody is because there's a preliminary appearance for a city case that I have yet to be appointed on.
You're going to be appointed on it. So we got citation 30092. Like, I don't know, just want to hand it to you out there. Loss prevention, it isn't. Yeah, she took like 3 things that are worth maybe $15 or something over out there.
Yeah, I have the police report as well.
Ms. Shanahan, while the prosecutors are talking, is your actual mailing address on Shuwa Road or not?
Yes, it is, sir.
Okay.
It's quiet.
And Your Honor,
Not sure why.
While we're on that, I did find.
I haven't had a chance to.
Violation of my.
Well, just to interrupt here, Mr. Kressel, I found PC on the shoplift from February 20th. So we have 2 back-to-back cases, and Ms. Shanneman, I just appointed Mr. Kressel to represent you on the shoplift. But I have a problem now because I have 2 cases back-to-back, which makes her a threat to the community safety.
And Your Honor, she was PR'd on state case.
Yes, she was.
And that's what threw me why she was in custody, because she did contact my office, but I was assuming she was out of custody. She has someone here that's an advocate for her as well. my understanding.
I don't have any evidence of that.
Is it Shannon? Shannon. Wanted to take care of and resolve this theft case as soon as possible, but I haven't had a chance to discuss anything with her. But unfortunately, this is all new information for me.
I have no idea what I said to you, but I'm sorry if I hurt your feelings. I do not remember. What did I say?
So on the first case, the state case, the assault case.
For that, we'll just wait for more reading in her plea, not guilty.
Thank you, yeah.
She was PR'd on that, and my understanding, her wishes are to resolve the shoplift case, which is the one that she's in custody on. But
she has no contact with Mr. Painter. Is that a condition that can be enforced? Is she going to stay away from Mr. Painter, do you think?
I think it should be the other way around. But I can't see what she will do, right?
Well, but here's the point. So, because we got the new city case, which is the shoplift, she doesn't have any kind of exciting history going on. I don't mean that in a personal sense, Ms. Shanneman. I'm looking at, you don't have any. She's got a driving while license suspended. That's right. She's got the 3 warrants. That was the problem.
But they're unextraditable to her, and so.
I know, but we had this discussion last time. It doesn't matter if they're non-extraditable. The fact is you've got 3 warrants, which means you don't go to court when you're supposed to. And then when you say something, then when you say something like you just did to the court, they're non-extraditable, what you're really saying is, I don't give a damn about those warrants. So you're not making any points over here at this.
No, sir, that is not what I was meaning.
I know you didn't mean that. I'm just trying to help you. It might actually help to stop talking. Do we want to bail on a shoplift or not?
The only concern I have, Your Honor, is that the shoplift appears to have been using maybe some alcohol items that were being, I think, of highballs or alcohol.
They are.
That's what I thought, not my brand. So, and that was what was being taken. And so I don't know whether alcohol is a factor in the earlier event that our colleague Cleone has. And so,
her lawyer's in there somewhere, I think.
I hate to keep her in jail on this stuff. Technically, I can revoke her release on the state case and put a bail on.
Be honest, John, I would ask for that because she was out less than 2 weeks and she got picked up again. Barely 2 weeks.
You see what a position you're putting me in here, Shanneman, and then when I say stay away from Kevin B. Painter, and the response is, well, he should stay away from her. See, that's not the thing. Just like you ignoring your warrant.
Just to interject.
Yes.
1, that's her advocate. 2, there seems to be a concern that this is, let's say, an unhealthy relationship. And she might very well be an abused party.
Suppose the court is worried about her safety and her judgment. Suppose she ends up dead in the next week if I let her out because she has such terrible judgment.
My understanding, and Ms. Shoneman, certainly correct me if I'm wrong, because I didn't have a chance to chat with you. I was just able to chat with someone here in the courtroom who was acting as your advocate. My understanding, you wish to resolve the shoplift case. Whether or not that gets you out of custody, though, is a difficult question for the court, because now the court's in a situation where you have a new charge while another one's pending.
It's crazy chaos.
I was gonna, if she still wants to proceed, that's certainly her right to do so. Otherwise, I was just gonna ask to set it out a week so I can chat with her. Dang it. But she doesn't have very much history. What she does have seems to involve a lot of driving to get to those places to take care of things. And she probably can't drive because she probably doesn't have a license, because one of those things is a suspended license charge. So that puts her in a catch-22 situation.
Well, if I treat her like I treat everybody else, I OR'd her on the domestic violence because I figured she could stay out of trouble. She didn't stay out of trouble, but I'm not going to revoke her current conditions of release. However, I am going to require $250 cash on the shoplift, because that's what I would do with any other human being in this world. She's on conditions of release on crime 1, goes out and allegedly commits crime 2. Maximum punishment, by the way, for the shoplift is 364 days in jail, $5,000 fine. You're going to have to post $250 cash to get out of custody. We're going to put you on for next week.
Yeah, I was going to say, if we could have arraignment on March 3rd, and if we could leave it on the 11 o'clock calendar, and if we could have the state case just kind of track along. The state case is probably going to require, because that's an assault charge, given what information I have, it's going to require some additional investigation, especially if there's concern with an abusive party that's the alleged victim. So if we could keep both cases on for March 3rd.
We will.
And Ms. Shoneman, do you think you'll be able to post $250 on the shoplift case?
I will after the first, but that money is in my wallet and I can't get to it. I did want to say that I did want to resolve the shoplifting case. And that I have on my own free will, have signed up for services for substance abuse with West End Outreach already. I have those appointments for set. And I've been seeing my therapist for the PTSD that I concur for the abuse. And I have not been in contact with Kevin Pater at all. And I'm staying away from him. The shoplifting was just a really stupid mistake, and it was less than $10, and I offered to pay for it inside, and I was very cooperative and stuff.
I understand that, Ms. Shanneman. You put me in a position where I have to be concerned about your physical safety because you don't seem to have good judgment, so I'm concerned about your life. I put $250 cash on you to try to save your life. So we'll see.
And Ms. Shanneman, I will call you. I don't know. This afternoon's a busy calendar, so I'm not sure if I'm going to be able to see you afterwards. However, we're putting this out a week. If you are able to post bail, you need to be physically in court next Monday. Otherwise, we'll take care of the shoplift case next Monday. Okay?
Okay, thank you.
It's at 1:30. Okay, for some reason I thought it was.
Thank you, Shanneman. Kevin King, don't go anywhere yet. Why don't you come on back? You come on back.
Don't worry, it's not going to last. It's the calm before the storm. Look at all those folders. Nothing's in the computer, which is crazy because every single Washington court case I do, it's all in the computer. It's just, I don't know what's going on here. District Court 2, but I don't know which district. Oh, it's Callum County. We were done. I would like to get that Australian man to speak a little bit more next time. All right. Back to Judge Fleischer, normalcy. Is that another judge? Doesn't that look like another judge? It's probably a lawyer.
Mr. Messina, Your Honor.
Okay.
This one, Your Honor, I'm just trying to get a future date. We had him set for an en banc mental health evaluation. but this was my fault. I got the date, but I didn't realize he didn't get text messages. I took a screenshot of the date and sent it to him.
Do you have a new date already or no?
I emailed Helena. I don't have one yet. And he also has a felony pending on March 13th. I don't know if we could just bring him back on that date and kind of leave that as a play state, see if I get a date.
Yeah, I'm okay with it. It's getting old though. It's 200 days. So just make sure that like, hopefully he can show up for the next one. Yeah, I trust you.
Showing up each time, so he has like transportation.
I trust you, Aaron. Yeah. Do you want to do the day after or do you want to do the same day since he's already there? Okay, whatever you want. Antonio, hey, do you have a plea?
I do.
Okay, yeah. Good morning, Mr. Richardson.
Good morning. How are you this morning, Judge?
What's going on with you?
I have a client who had a calendaring issue yesterday, her and I, and we failed to appear. I was going to ask the court if we could reinstate the bond and appear in the morning.
What's the cost number?
The cause number is, I've got it right here, 25482340.
On white?
Yes.
Are you representing her now?
I am. I know I need to get my letter rep in, and I'll do that as soon as I get off the phone, but it was kind of a mix-up, and I wanted to get on here pretty quick.
Okay, and what is your, do you have a SPIN number?
66867680.
So 6686-7680.
Correct. One of the old ones where you put a 5 in
this one.
Or
You ready? Yeah. Which one do you want? The spin first? Spin first. Okay, it's 6686-7680. And the cost number is 254-8234.
And he's hired? Tuesday.
Yeah.
Okay. Waive the parents, defense to move back.
Angela White, come up.
She's not present, Judge. I was asking if we could appear in the morning.
Oh, well, I'm not going to reinstate it until she's here, right? She needs bond conditions, right?
I think she's got bond conditions. I think she already had those.
A bond violation report, Judge.
Oh, yeah, she has a bond violation.
Oh, does she? Then I'm not aware.
Yeah, I'm not reinstating it until she gets here. Sorry.
Right.
She's got bond what's the violation?
The violation is for a high brat.
She's continuing to consume alcohol, Mr. Richardson.
Right.
Sorry.
Okay, well,
so the warrant will remain in effect until she gets here or she gets picked up. But
all right. Well, I'll make sure she gets there. We don't want to do it the picked up way. And then I'll approach again by Zoom then, Judge. I'll probably early in the morning. Thank you.
Do you still want me to attach you or no?
Yes.
Yeah, okay. Right. We got you. We'll attach you then.
Thank you, Judge. We'll see you in the morning.
Take care, friend.
All right.
Ramona, I'm going to chat you right now.
Okay, Judge.
I skipped that first one because I don't know if there's a translator, and Lori doesn't like it when two people are talking at the same time, which means she really hated that last clip.
Oh, you know what, Judge? Since I have you, there's another case I need to talk to you about.
Okay.
Sorry, I just looked at my list. Mr. Eric Dome?
Custody or on bond?
He's on bond in ICE custody.
He's in ICE custody?
Yes, he's battling it out over there in ICE custody.
Are you 100% sure?
Yes, so here's the update. I've been giving you updates on this gentleman every 2 weeks. So last time he had an attorney, he was denied an immigration bond, but he was given, they started talking about asylum. So he's getting an asylum application that's pending or about to be submitted. He's going to have court on March 19th.
Okay.
So we should have word from immigration on March 19th.
Okay, but you've been able to verify it's still in ICE custody?
Yeah, okay, look him up again.
I'm okay with the reset then.
Yeah, okay, so after that date. Okay, perfect. Thank you. Yeah, he's in ICE custody. He's got a hearing date and everything. All right. Hey, this is Mr.
Good morning, Mr. Jackson.
Good morning, sir.
Jackson, your lawyer's asking for me to set you a bond. I don't know. The only thing I know is that you're wanted out of another jurisdiction. I don't even know for what. I don't know if I'm going to set you a bond, but two things are very clear that I need to know. Number one, if we set you a bond, are you going to go back? And number two, if we set you a bond, are you going to be a danger to our city? Because that's my primary concern. I want to keep my streets as safe as I can.
Yes, sir.
Do you understand?
Yes, sir.
I know that you're going to tell me it's lollipops and gumdrops and rainbows and this and that, but I have to get you in a very short, I have to get to know you in a very short amount of time. And the way I get to know you is how you look on paper, because that tells me really who you are. With that, let us know about Mr. Jackson.
He's wanted out of Greenfield County, Colorado for failure to appear for burglary. The bond over there is $50,000. This was a case out of this was issued out of 2023, October.
So has he been on bond?
No.
Did he know that it was out there? Is it a to be?
The failure to appear.
Oh, failure to appear. So he knows that this has been open for the last 2 years.
Yes, Judge. State's opposed to a bond as well. Of course, as the court knows, he has an evading with a motor vehicle out of the 209.
No. What?
Yes.
He has an open evading as well in a motor vehicle.
Yes, he's got a case pending here in Harris County as well. Invading, that's right.
What are the criminal history? If any?
His other recent one was from 2022. He had that's which was a state jail. He was given, I believe, a deferred and it was revoked in 2023.
Wait a second. So you're telling me that that case has been open. It's been in a warrant status since 2023, and he was able to get on a felony probation in 24 here while that case is open over there?
Looks like it.
The case that I caught.
Yeah, so that one was filed in 2022, and then they revoked it in 2023, October.
The reason why I got the warrant is because they took me because
something doesn't add up.
But I made it to all my courts. I never missed a court day before this. Okay, in Colorado is what you're talking about? Yes, sir. Okay, understood.
Yeah,
Judge. So there was some back and forth on when he got taken into custody for the last case. He's saying that he didn't miss a court date because he was in custody at that point, and so there's a lot of back and forth. The situation I'm talking to him about is, hey, judge is going to say you've had this case pending since this time. He has a plan in place to go to Colorado. What's different is that he now has a daughter that is 2 years old. So he's trying to do right by her. And so that puts more responsibility on him. He does have the evading case, but he would like to see if he could get a bond here because the trouble he's getting is people aren't allowing him to post the other bond because of this fugitive case. And so it's kind of which one comes first. And we're hoping you could give him.
The is that case has been open. Are you telling me it's been in warrant status for 2 years, Amy?
Yeah, the Colorado case is from 2020.
He's known about this thing. It's been open for 2 years, yet he's never done anything to go back to try to rectify the situation. Now, because he's arrested, now he's all ready to go.
Well, the difference is now he's got his daughter and, and so he's growing up fast.
Jackson, I can't trust you to do the right thing. You've had 2 years.
Yeah, no, at first, I ain't have no money to go out there.
That's a good point I mentioned before. Yeah. He is also mentioning to me his finances, what his finances were back then. He was 19 at that age. His finances are a little better now. He's got the support of his wife, I believe, or his girlfriend.
My girlfriend.
I don't.
And also, Harris County been putting me in and out of jail since I've been incarcerated in Harris County since then. So I really ain't have no chance to go out there. I only been inside the world for like a month and a half, almost 2 months.
Okay. Judge, we're not asking for a PR bond. We're just asking for a bond enough to ensure for him to go out there and turn himself in. He still needs to make the bond. And so this would at least put something in place where he can make this bond and make the other bond. And if that doesn't happen, if he can't do that other bond, we're approaching, we'll pull.
Here's the thing, Mr. Jackson. I appreciate the argument that you guys are making. I truly do. But the fact remains is that case has been open for 2 years. And to say that money has become an issue, I just don't, I don't believe it. And the thing is that you've had a long time to be able to do the right thing, to go take care of that. And yet, in between that time, you're still picking up criminal cases here, and it's still, nothing's happening. I feel if I were to give you a bond, I don't think that you would go back. I just don't want you to pick up another case. I don't want more harm to come. I'm sorry, man. I'm not going to do it.
Would you reconsider if he does make the other bond first?
No. But the point is that you've had 2 years to get and do the right thing. And no matter how much time that you've come.
If it's about the bond, go ahead. If it's about the bond, don't talk about this case in specific, but go ahead.
They had,
Talk to the judge.
Okay, Judge, during them 2 years, I ain't gonna lie, I've been incarcerated 2 times. The first time, I would have never missed court, but they took me in a day before my court date. That's the whole reason of me having a warrant. And when they took me in, that's what slowed me down on a lot. I had my daughter, my mother got cancer right now. I ain't gonna lie, like, I don't know, like,
It's always the right time to do what is right. You
Yes,
ever
sir.
said that?
Yes, sir.
Right. You've had 2 years to get it done right. You've not been incarcerated fully for 2 years. Now, all of a sudden, because you're in custody.
Sir, I only had 6 months out of 2 years, sir.
I'm not gonna argue with you.
Yes, sir.
I've got to understand that at some point,
Yes, sir.
you cannot just continue to, no. It's time now to face it. I can't just continue to let you out and trust that you're going to do the right thing. You've had that opportunity over and over and over. And yet, after 2 years, you still haven't had the wherewithal to get it done. Why is that going to change now? I don't think it will. You know what I mean? Actions speak louder than words. And I hope that you remember this in the future so that if you do have something else elsewhere, take care of it, because that warrant will always be there forever and a day until you take care of it. You know what I mean? Okay.
All right, thanks, Judge. Appreciate it.
Morning. Here on Anthony Arthur Lee. Court coordinator wanted me to approach because
they filed a motion to sub. I just wanted you to know about it. So
a motion.
I'm sorry, motion to amend. Yeah. So I just wanted to give you a heads up that they had filed it so you could see it.
Yes,
Judge, I'm just putting it right here.
Okay.
Yeah, it was due to the blood coming back.
Right. So I'll sign it, and then whatever you guys want to do. Yeah. Okay.
All right. Thank you.
Yeah, it's just normal reset. Whatever you guys need. It's an early case. So.
Thank you.
Sure. Mr. Elick. Hey.
I have Kareem Khalifa, and he's on the docket, but he wasn't brought up. And it looks like the state is going to go to trial, and so we're going to get a trial date.
Okay, just whatever day you want.
I also am going to get an interpreter, and have to make a few calls, so I may file that and approach tomorrow on that.
I'm okay with that, whatever you need.
Okay.
Yeah, I mean, if you need money for this or just whatever
I
you
think
need,
I will because text to me.
whatever you need, don't worry about it.
Thank you. And I think
Can you come to the back?
yes, I will. And I think there was a Samantha Walker who an attorney, was it an attorney at Litem possibly that
I don't
called?
know. The thing is this, is that we were supposed to get conditions signed by her and they never got.
So what happened?
It says on hers, it says state will supervise conditions.
Okay.
And state conditions were never signed. So that's what, we need her to sign the conditions. That's what we need.
Judge?
Samantha Walker.
No. Hey, Victoria, do you have the case number for Mr.
It is 2537179.
So I recall the day I was appointed that the chief, I showed the chief the surveillance video which the state has, and then we approached with the chief, and this was in November, and I recall you saying no conditions. And then the magistrate conditions were in place, and then last week she came to court.
It's an assault family member though. We always do.
Well, it's her daughter, and her daughter actually has a juvenile case.
I have to stop real quick and say thank you to Red. Red, thank you so much for the super chat in my comments. I really, really appreciate it. Thank you.
And I showed.
Okay, so I'm glad that you're here so we can talk about this. What, see?
And the white lily flower. Thank you. That's a good idea. Amazon. The only problem is I need white lily, but in the north, the biscuits just don't rise. Even with white lily, but I have to use white lily if I'm going to use anything.
You, Alex.
I think it was.
The issue is I'm not seeing any state's conditions filed on Ms. Walker's case, no granted conditions. I only see the.
Felix is saying that I had decided not to put conditions.
And you said, I wish there was more mothers like you, specifically. And I believe you.
Sheila, I believe you. You're an officer of the court. I trust you. So
I see no notes of any conditions either, so I'm inclined to believe Mr. Elo.
Okay. All right. So there's, okay.
And I can also tell you last week, I believe, maybe it was a week ago, Friday.
She called us after docket as well and was talking about this.
And I believe.
So Miss White called?
The mother, yeah.
Mother, which, yeah, she should have gone through me, but I believe they were going to release her daughter out of juvenile custody into her custody. And then there was the magistrate's no contact order, which had been put in place by the magistrate. And so they didn't do that. So now the CW still remains in custody until this gets cleared up.
So you need us to take it off?
Pardon?
You need us to take it off?
I think she has no conditions as of now.
She doesn't have any conditions.
And so I believe that would allow the court to place daughter back with her, which I think is in the best interest of everybody.
Okay.
Yeah.
Okay.
Okay.
Yeah.
All right.
Then I think we're on the same, right?
Sounds good. Thank you.
Hey, good morning, Mr. Booker.
Good morning. Judge, I have two clients I need to talk to you about.
Okay.
The first one is the more sophisticated one, Tarlin Stevens.
Is it on docket today?
It is, Judge, and she's in the court. Just talked to Chief about this. It's a DWI. It's her first interaction with the court system. Okay, so the state made an offer of probation that included the use of an interlock. So she and I have been talking about this, and that's a condition that she preferred not to have. And so the question was whether you would approve of probation without an interlock in this case. And if not, then we're going to continue down the road of PTI potentially.
The beard makes him look great. I love it. I am going to go find a client. Oh, here we go.
They'd send that in yesterday. And then they will provide her with a certificate of completion, and then she'll be finished.
Yes, let's roll it till later in the week.
That's what I was thinking, Judge, if we could.
Okay.
All right, thank you.
Yeah. We're approaching with Mr. John Mayer. We have a plea
It should be before the bench? Oh, on both. Yes, sir.
I hope so. Jesus. Pressure.
Did you just get appointed today? I did. Did you want time to look to see about any discovery or anything?
Well, I've spoken with Mr. Mayor, and I've gone through the offense report, at least what's here in the dams. One of the theft cases is for $103. The other one is like $289. And he is under the impression that, you know, that taking a plea on this case would be more beneficial for him because he can't afford to pay two $5,000 bonds.
Mr. Mary, all I want are my streets to be safe. That's all I want. We gave you a PR bond on your first case. You took off. You didn't come back. We gave you another PR bond. And this time, on the new PR bond, you picked up another case.
That's true.
The point I'm trying to make is I don't want people to plead guilty just to get out. That's not what I want. What I want is no more issues. That's what I want. So I don't want him to plead guilty just to get out. And I feel that that's happening here. So if I give you a third chance, how do I know you're not going to pick up yet another case? Mr. Mary, we have resources here. All you have to do is ask. If you want food, if you want clothes, if you want something to, eat, if you need a place to sleep, if you want a job, we have resources for you. All you have to do is ask. But this is a problem because with this right here, pick up another one, you're now looking at a felony charge.
On that first case, it looks as if those were work tools that he was appropriating. On the second,
Let's not talk. Look, I don't want you to plead guilty just to get out. That's not the way that, but I'm going to tell you now that I don't like to play games. If I give you another PR bond, and look me now, because if I find that you pick up another case where you don't show up to court, we will have issues. And I'm telling you, I will not do it. This just to plead guilty to get out. It's not going to happen. Do you understand?
Yes, sir.
I will give you another chance. I don't want you to go to any more Home Depots. I don't want you to go to any more, Walmart, right? No Walmart. Do you understand? Any of them. No Home Depots. And I will have you speak to counsel now so that whatever you need, we can try to get for you. You understand? But this is not a good way to it's setting you up to fail. And that's not what we do. Do you understand, Mr. Mary? Okay. I'm going to grant you a PR bond on both cases, but we need to find out where we're going to go next because I don't want any more issues. You must appear in court every single time, and I want you to stay in contact with counsel. He's going to give you his cell or a number to him. There's no excuse why you can't get in touch with him. Do you understand?
Yes, sir.
Really, I'm not asking much. Just don't pick up any new cases and stay in contact with counsel. That's all I'm asking you to do. You understand?
Yes, sir.
This is not the right way. All right. So if you don't mind speaking to him real quick to see what we can work out for any kind of resources he may need.
Yes, sir. Thank you.
I'm just gonna just to the floor, you okay?
That's what.
Approached, he raised his bond to 5,000 and notified the family and the homeless. And he insisted that he was coming down today. So he is here today, Judge. We have a 1-year defer worked out with the.
Come up, Mr. Serrato. Man, he couldn't even get to court. How's this dude gonna work a probation?
His mom is behind him. He's got it's 16 hours of community service, which he knows he can get to do. He has 2 online classes and he has to write some letters of apology. He knows that this is his chance to keep this off his record. I've talked to his mom. They are behind him. They're going to help him do this, Judge. Give him a chance, sir. He can do it. Right, Gail?
Yes.
We have at least 3 times you couldn't make it to court. Just to even come to court. How on earth are you going to be able to make a probation? You couldn't even come to court.
Well, for some of them, it wasn't entirely my fault. For one of them, I came to court, but mostly when I'm anxious, I get sick, and I had like a huge headache, and I ended up getting food diarrhea because of it, so I couldn't come. So I had food poisoning for maybe 3 weeks. I couldn't control that, so I'm sorry about that. For yesterday, my mom paid the insurance, and it's expensive, so we didn't have any money until today because my dad got paid today. So we couldn't even get family members either because they live far away. So if they came here, I would have probably came here around like 10 or 11.
So you have all these issues now. You realize you get on this probation. There's no excuse why you can't go to probation. There's no excuse why you can't do your community service. There's no excuse why you can't do your classes. If you don't, you're looking at an entire year in jail. This is not a joke. So you either do it the right way or you end up in jail for up to a year.
It looks like the camera's playing a trick on me. Like, John is so tiny next to him. So tiny.
In life, you have to act a certain way we do things, right? You're expected to behave in a certain way. And when you don't, there are serious consequences. I had given you multiple chances to try to get here. I worked with John to try to get you here. And this last time was the 3rd time that either the car broke down that was the last 3 excuses where the car broke down. That's why, to me, that's unbelievable. And I'm not going to accept that my car broke down for a failure for you to complete your community service on time. Do you understand, Mr. Serrato?
Yes, sir.
This is a very big deal right now because I want you to understand something. When you end up with an assault on your record, it closes very many doors because when you try to get a job and if someone sees that you have an assault on your record, what do you think they're going to do? What's that?
Decline.
Right. Because they know that if you get into a potentially stressful situation, something might happen. They don't want that kind of liability. John has worked out an agreement where it's a probation, where if you do a couple things, you don't end up with a conviction on your record. But this is not a joke to where, I can't make it to community service because my car broke down. I'm not going to entertain that excuse. Do you understand that?
Yes, Judge.
Can we hold the probation here? Or is it too difficult to do that? It's too hard. It's okay. Did you graduate from high school?
Not yet, sir. He's at Eisenhower right now, Judge. He's still going to school. We have to get
Are
him
you
a pass.
actively enrolled in school now?
Yes.
Okay. I want proof that you're actively enrolled, and I want, what are we now? What, February? So it's, oh yeah, there's still school. I want a week to bring proof that you're enrolled in full-time in school. That is a part of your condition as well, that you graduate from high school. Do you understand?
Yes, sir.
You're not to consume alcohol or illegal drugs. If I find that you're smoking weed, I will issue a warrant for your arrest. I'm going to put you in. You're looking at up to a year in jail, but I'm not going to let you go. At a minimum, until you graduate from high school. You will be with me until you graduate from high school. Do you understand?
Yes, sir.
Are you a junior or a senior?
A junior.
Wonderful. You will be with me for the next until you graduate, because that is now a condition as well. An effective decision-making class, a 2-hour anger management class, no drugs, no alcohol, 16 hours of community service. As long as you're enrolled in high school, then I will waive the community service. There's no need for you as long as you're in school and studying and doing well. Failing does not equate to being enrolled in school. Failing does not count. At least a C average. Do you understand?
Yes, sir.
An apology letter to the complaining witness in this case. If you violate this probation, I'm going to issue a warrant for your arrest. I'm going to put you in jail. We will have a hearing to determine whether you violated the probation. I can either extend you or keep you in custody. I want you to know that this is not a joke. Do you understand?
Sure.
There is also an affirmative finding of family violence, meaning that you ever pick up another one of these cases again, you will be looking at a 3rd-degree felony, 2 to 10 in the penitentiary. Do you understand?
Yes, sir.
You can never own a gun or ammunition as a result of this as well. Do you understand?
Yes, sir.
Kelly, thank you so much. Thank you. I appreciate it. And I'm so glad you come every day.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. You know what the consequence is if you violate this probation. Everything must be done on time. You have a certain amount of time to get things done. If you don't, you are in violation of this probation. If you pick up a new case, you're in violation of this probation. Do you understand?
Yes, Judge.
Okay, so let's have him drug tested in 2 weeks, please. And then I guess let's do both. So in 2 weeks, do confirmation of enrollment and a drug test. How do you plead to the office, Mr. Serrato? Guilty or not guilty?
Guilty.
I'm not going to find you guilty. It would probably be best for you to make this thing work out, because you could really lose big if you don't. It's not about the money. It's never about the money. I don't care about the money. I'm going to waive every fee that I can on you. It's never about the money. I don't give a rat's behind about it. I just want you to do what you say you're going to do, and I don't want you to smoke marijuana. Do you understand?
Yes, sir.
Do you have any questions?
No, sir.
All right. Love you, sir.
Thank you. Thank you, Judge. Thank you. You're going to talk to this lovely lady.
It's always about the money. Always. Stupid money. All right, guys. For some of you, for everyone, it'll redirect you if you don't leave yourself to OJ. Some of you will stay at OJ. I'll see you in like 2.5 minutes. Everyone else, thank you so much for coming out. I really, really appreciate it. Thank you, mods, so much for helping me. I appreciate it. And I will see you all very soon. Behave, guys. Bye.